SJC-10260 Electronic Data Systems Corporation versus Fair Labor and Business Practice Division.
Good morning, Mr. Morris.
Good morning, Your Honor. May it please this honorable court. This case involves the same parties and raises the same issue that was before this court in 2003, namely whether an employer must pay a terminated employee the cash equivalent of unused vacation when the employer's vacation policy provides that no such payment is due. Now, under the earlier version of the EDS vacation policy, the policy simply said if you leave EDS, you will not be paid for unused vacation. This court in 2003 deemed that policy ambiguous, construed the ambiguity against the drafter of the policy, EDS, but in so doing expressed no opinion as to whether what it called a forfeiture of vacation pay would be permissible in the case of a voluntary or involuntary termination. EDS has amended its policy. We believe has eliminated any ambiguity in the policy. So we are back again, as it were, raising this issue.
Mr. Morris, is there anything in the record as to when the employee begins with a T and ends with a 9, but I forget.
Tessaccini, I believe.
Mr. Tessaccini was notified that his job would be eliminated as of April 1, 2005?
I believe it's in the stipulated facts. I believe it's a week.
It doesn't say when he was told. It says that a week before he asked about this, but I don't know when he was told. But
I thought it had stated a week before that that there was a week's notice, and that's why he inquired about the vacation pay. I don't know if it goes into all the detail, but that's my understanding.
If just a matter of curiosity, if the employee in this case was out on vacation, like the 3 or 4 weeks vacation that he had otherwise been entitled to, if he was out on vacation, could EDS during his vacation have decided, well, we're going to terminate his employment, he doesn't get any pay for the rest of his vacation?
I believe they could. They would have to pay him his vacation for the days that he was on vacation prior to his termination. But an at-will employment presumably could be terminated at any time, including while somebody is on vacation. So there could be, that's not the case we have here, but yes, I think they could. They would have to pay, however, for the vacation taken up through the date of separation.
is an employer required to provide an employee with vacation time?
Not at all. And I think the Commonwealth and EDS agree at least on that point, that there's no requirement to provide vacation. But it's our position that under Section 148, the language of a statute on vacation, which is very brief, that the term wages shall include holiday or vacation payments due an employee under an oral or written agreement, that it's our position, and we believe Judge Borenstein in 2004, after this court's decision in 2003, said it best, that the Wage Act is merely the method by which private agreements regarding vacation policies may be enforced. So in order to decide whether vacation is due, you have to look to the terms of the policy. And in our view, the policy does not provide for payment. It draws a line, if you will, between employment. If you're on vacation, you are paid. You receive paid vacation. But at separation, you do not receive the cash equivalent for that. Now, the Commonwealth and the Superior Court below are of the viewpoint, and I don't believe I'm mischaracterizing it, that by virtue of the EDS policy, as I think virtually every vacation policy states that if you have to earn, you have to work so many years, and you will be provided so many weeks of vacation, usually on a graduated scale. And the assumption seems to be that by providing vacation, in fact, I believe the Commonwealth goes so far in its brief as to say, should the employer provide vacation, the Wage Act dictates that vacation payments must be treated as wages at pay of termination. That by providing vacation under any kind of schedule, therefore, the cash equivalent has to be paid at termination. In our view, I'm sorry.
I mean, I'll ask the Commonwealth, but as I read that, I took it that they say that you can't have a use it or lose it. So that if, for example, you are under the policy entitled to a month's vacation, 3 weeks vacation a year, and you work for 30 years, and you decide you don't want to take vacation, that you can't have an internally operating policy that says if you don't use it within 1 year, which is what many employers have, that you would have to pay for all unused vacation time. I assume. I mean, I'll ask the Commonwealth, but that's what they seem to say.
But they take the other point
No,
of view, actually. The
yeah.
Commonwealth says use it or lose it policies, for whatever reason, are okay, although they would seem to be very similar to this. But this policy is not.
Well,
Yeah.
it's only similar to this if you're talking about voluntary leaving. It's not similar if you're talking about an involuntary termination.
If you wanted to, if there were a distinction that the statute permitted between voluntary and involuntary separation, then theoretically, perhaps, I don't want to concede anything, but there might be some basis, but we believe there's a real... I'm sorry?
I take it that if it appears that the termination was triggered, if the employer knew that somebody was going to use their 3 weeks vacation, and to go to Justice Steener's point, either while they were on vacation or the day they were leaving for vacation, you can always bring a violation of the implied covenant of good faith and fair dealing, correct?
There would, yeah, I believe there would be such a cause of action. But I think on the use it or lose it point, there's just well, at the very least, there's a real tension in the Commonwealth's position, because if an employee, if under, as they say, if an employee has earned, has received entitlement to vacation and has therefore earned wages under their position, then why can the employer then set a condition, you have to use it within a year or whatever it is, and then it can be taken away if it's wages?
Well, because they could, if let's say by December 1st of a particular year, the employee had not used any of, let's say, a month's vacation time, the employer could, at that point, say, leave. Walk out of the office and spend the month of December at home or wherever you want to go. That's your vacation time. We don't want you on board during that 1 month. They could send the person home.
Theoretically, they could.
Well, theoretically, unless there's some countervailing thing that says you've got to arrange in advance. You can't have employees just taking vacation time whenever they're going to run out, correct?
No, and I think the EDS policy, like other vacation policy, provides the employer with discretion whether to grant vacation. Under the manager has control as to when employees can go out, so that everybody isn't out at once.
So it raises the difficult position that if somebody doesn't take vacation time until December 1, let's say they're 30 days of vacation, and then says, I'm going to take off for the rest of the year. This happens to be a cyclical business, that December is a very, very busy time. And the employer says, no, you can't take it off now, and you're going to lose it at the end of the year. Does that give them a claim under the Wage Act? I mean, I'll ask that of the Commonwealth. You would say unquestionably no, because...
Yes, but under the user, if a user lose it is permitted, taking the logic of the Commonwealth's position under this policy, that employee, maybe they couldn't take vacation in the month of December, but they would have to be paid the cash equivalent,
Exactly.
even though the policy might say, as if you don't use it by December 31st, you're going to lose it. We just believe there's a real tension in the Commonwealth's position on that point. We would also point out, as we cited in our briefs, there are statutes in the Commonwealth that explicitly provide, I think it's page 27 and 28 of our brief, that provide for the payment of unused vacation. I believe retiring judges are included in that group, but that has not been done in Section 148. It could be done explicitly. There are other states, I believe Illinois and California, specifically provide for that, but that has not been done in this situation.
Now, are there any limits to the principle which you argue that since you can not give vacation, you can define what you get? For instance, if the employee were to take all 4 weeks in January, could your policy say that if you don't finish the year, you owe us for, if you leave in, if you're fired in March and you take 4 weeks in January, that you owe us for some period of that vacation?
I don't believe so. I mean, I'm not 100% sure, but I don't.
Well, why not? I mean, if your policy specifically says you have earned it, but if you...
Well, if you've already taken the vacation, so how could you...
Well, it's usually retroactive. You have to work for a year, and then you're entitled to 4 weeks. So if you work for a year
Right.
and you take the 4 weeks, you're in fact taking the vacation for the prior period, correct?
Unless the
Right.
policy specifically indicates you can take it in advance
But
and
you've already-
bank it back.
I'm sorry, maybe I'm not following, but if you've already gone out and taken the vacation time and been paid for it, there can't be a repayment of that. The EDS is...
But isn't that what you're essentially doing here? I mean, if this employee was due, I think, 4 or 5 weeks. If the employee had taken those 4 or 5 weeks, you wouldn't be here. You would say that
No.
money has already been, he's earned that vacation because he had accrued those years. Aren't you essentially saying that if you don't take your vacation in January and are fired or leave before, we can take it away from you?
No, but isn't the difference that you're saying the difference is that it's not earning or not earning, because you say it doesn't get earned, it's whether it's used or not used. And you're only dealing with the not used part. So if the employee had used it in January, so be it.
Correct, and the statutory language allows, references to due under an oral or written agreement. The agreement is clear. If you are separated, and a certain time vacation time hasn't been used, you are not paid for that. And the legislative history, in fact, which is cited in our brief and also in the amicus brief of the New England Legal Foundation, it's also in the MBTA Superior Court opinion, talks about that when the statute was amended to deal with vacation, it initially had just added the expression due an employee. There was no reference to an oral or written agreement. However, in the legislative process, the statute was amended to add the phrase oral or written agreement, or under an oral or written agreement. And we believe that expresses a legislative intent that the court has to look to the oral or written agreement. And we believe that the EDS agreement, the vacation policy here, is a reasonable, is consistent with the overlying purposes of the statute, that it draws a line between paid vacation during employment. There's no interference with that. People are paid. However, when they separate, there is no payment for unused vacation.
Okay, but isn't and maybe this is what Judge Gantz was asking, but isn't the fact that you get more and more the longer time you're there, how do you avoid, other than by simply saying it, but how do you avoid that the substance is that this is earned vacation? It has been earned. And therefore, maybe it qualifies as wages. Because if you've been there 2 years, you certainly don't get five weeks. You have to be there 20 years. So you are earning that time.
You are earning that time, but still, you have to be employed in order to be paid for that time. If you haven't taken your vacation prior to separation, that's where in our view, the language "due under an oral or written agreement" kicks in. That you have to be employed. If you leave, we're not going to turn this into a severance pay, if you will, the cash equivalent of the unused vacation. We believe that is consistent with the statutory language.
Thank you, Mr. Morris.
Thank you very much.
Mr. Conway?
May it please the Court, my name is Kevin Conroy with the Commonwealth. With me today is Marcia Hunter. Let me start here. The Attorney General issued an advisory in 1999 interpreting the Wage Act. We think that interpretation of the Wage Act is reasonable, and we would urge this Court to show substantial deference to that interpretation. Under the plain reading of the Act, the word wages shall include
Could I just ask you this? If we agree with your position, how can you endorse a use it or lose it?
Sure, Your Honor.
I mean, I've read your brief, but how can you endorse that?
Under a use it or lose it policy, an employer needs to do two things, Your Honor. First, an employer needs to provide a reasonable notice of the use it or lose it policy.
Yeah, which they've done here.
Absolutely, Your Honor. And second, they need to provide a reasonable opportunity for the employee to use their vacation time.
I understand that, but those are public policy decisions.
And we would read, Your Honor, the special contract provision, which says specifically, no person by a special contract with any employee or any other means may exempt himself from this section. We read that language that's part of the Wage Act as preventing a forfeiture.
Can I give you another example? The employer has a parental leave policy that says if you give birth to a child or adopt a child, you can take, pick any number, 10 days. Right?
Mm-hmm.
And, within, the first month. And the employee is discharged sometime after that. I mean, are those wages? Can you be compensated for that?
I think, I'm not sure I know the answer to your question, Your Honor. I think at the heart of this, though, with this vacation payment is it offers paid time off.
No,
and provided
but this is paid time off. I'm talking about paid. It goes to Justice Cowan's question. In other words, if there's no requirement that you give vacation time, there's
Correct.
no requirement that you give parental leave time, there's no requirement that you say you can have free personal days, and for good personnel practices, highly competitive market, you want to meet the market, whatever it is. It's not unusual to say if you work for an employer for a number of years that you get slightly increased numbers of days that you can use. All of those, it seems to me, what the Attorney General is asking us to do is to turn those into an agreement to compensate if you leave for any reason.
I don't, respectfully, Your Honor, I think what we relying on the plain language of the statute, which says under an oral or written agreement, if an oral and written agreement provides for vacation, that vacation becomes wages, Your Honor. And under the plain reading of the statute.
But then that is I know you say, provided that you've got reasonable time and reasonable notice within which you have to use it, but you're asking us to build into this, all kinds of policy decisions.
But I think if you read that sentence, Your Honor, in conjunction with the special contract language, what you come to is that what the Wage Act is intending to do is prevent the forfeiture of wages. And provided...
And in this case, the employee was paid for every day that he worked, correct?
He was paid for every day he was worked, Your Honor, except that he, as part of his compensation, Your Honor, he was offered vacation days. Those vacation days became wages, Your Honor. And so when he was terminated, he needed to be paid in full, as the Wage Act specifically says. Very broad language, Your Honor.
Can I ask you this question? Would you be taking the same position if he just decided he was going to go get a better job, hadn't used his vacation that year? I'm going to go get a better job, pay me the money.
In the situations when an employee is leaving voluntarily, those are very rare situations. Do these situations come up?
What do you mean they're very rare? What evidence is there in the record that they're very rare?
Your Honor, when an employee leaves voluntarily, we just don't. I agree, Your Honor. There's nothing in the record about that.
There's nothing in the record. So what's the answer to that?
Excuse me, Your Honor. The answer to that question is that is wages. That those would be wages as well.
So they have to be paid as well?
Yes, Your Honor.
So this
So
has
that you
nothing to
can
do with
never-
voluntary or involuntary severance or notice or anything else. This has just got to do its wages, and that's it.
Yes, Your Honor. These are wages.
You would say, you would say that an employer could not design a vacation policy and have an agreement that says if you leave voluntarily, you will
Not be paid.
lose,
What-
and you have unused vacation days for that year, you will lose them? You couldn't do that?
What I would say, Your Honor, is that this is wages, and usually in the
But if you
situation.
say that, I mean, my difficulty is then how can you say on the one hand you can't do that, but you can have a use it or lose it policy?
Your Honor, because under a use it or lose it policy, there's no forfeiture of wages.
Certainly there is.
But
The
how is
same
there
if you
not?
leave voluntarily, there's
Be-
no forfeiture of
bec-
wages.
excuse me, Your Honor, if you have the opportunity to use that vacation time, and you've had a reasonable opportunity to use that vacation time, I agree, the voluntary situation raises a much more difficult question. We rarely ever see those
But
cases.
of course you don't see them because there's probably no basis to see them.
Well, because we don't see those cases, Your Honor, because generally an employee will use his vacation time knowing...
We don't know that. You don't know that. You're asking us to assume facts that are not in the record.
And I guess I would say, Your Honor, the question of the voluntary departure is not before the court in this case either.
Are you asking us to make a different policy?
No, Your Honor. What I'm asking you to find is that if an employee has been involuntarily terminated, that he should be compensated for his vacation time.
Where is there anywhere in the statute that draws a distinction between voluntary and involuntary departures?
Because, Your Honor, the special contract provision says specifically no person by a special contract may exempt himself from the section.
But
And
what does that have to do with
Well,
voluntariness or involuntariness?
Once an employee has been offered vacation times, it becomes wages.
So how can you lose it if you don't use it?
And what I would suggest, Your Honor,
It can't be, forgive me, Mr. Conlow, it can't be that if the employer says we're going to pay on the last day of every month, not bi-weekly, we pay monthly, right? And by the way, if you leave voluntarily, we're not going to pay you. Can't do that, right? It doesn't matter. It doesn't matter. The statute says you have to get paid within a certain 7 days, as I recall, right? It doesn't matter whether you leave on the 2nd of the month, right? There's a statutory provision that says you have to get paid because that's for work done.
all due respect, Your Honor, the statute says you need to be paid in full upon discharge.
Right. I don't know whether there's any leave time or not. I can't recall.
But with all due respect, if vacation time is wages, you need to be paid in full upon discharge. And that gets to the heart of the Commonwealth's argument here, which is this is wages, and you need to be paid, and the statute specifically provides that you need to be paid in full upon discharge. EDS's argument that the Wage Act merely provides a method by which private agreements regarding vacation policies may be enforced, that is inconsistent with the purposes of the Wage Act, which talk about the unreasonable detention of wages, and is also inconsistent with the special contract provision. The special contract provision says the protections of the Wage Act are unconditional. There is no negotiation over these terms. An employee cannot waive his rights under the Wage Act.
I know that's, I see your argument, but it seems to me the way the statute deals with vacation is just different because it talks to the payments that are due under an agreement that can take many different forms between a private employer and an employee.
I think that's not an unreasonable reading of the statute, Your Honor. I would say our reading of the statute is more reasonable, however. I think that the term vacation payments implies that this is compensation. This is money that once it's...
I take it your position is, and I know that you're dodging the voluntary, involuntary, but I take it that an employee who wants to leave knows, in fact, has an offer, hasn't told the employer that he wants to leave to go to another position on September the 1st, could take no vacation time at all. He's earned the 4 weeks because he's finished the first year, and he is asking for a payment in money on the 31st of August. So an employer who decides that they will give 4 weeks vacation time, it has not contracted, because they can manage the workload, but they may not be able to manage the payment out, is beside the point. Correct?
You are correct, Your Honor, that I'm trying to dodge the voluntary, involuntary nature.
No, I'm just trying to think. So if an employee deliberately doesn't use vacation time, knowing, so in order to get, as it were, a double check on August the 31st, payment for the work done in August and payment for the work not done in September because he or she was entitled to vacation time, every employer has to pay that cash amount out.
I would say, Your Honor, that this court doesn't need to get to that question. I think what this court has before it is the question of whether wages were forfeited in this circumstance. When an employee was terminated and did not have a reasonable opportunity to use his vacation time. And I would say I don't think the court needs to get to that next level here. Here we've got a case of a termination where an employee was specifically had vacation time that he was provided for under the contract, and he did not have an opportunity to use that. And in that case, I think that's a violation of the special contract provision, and that there's a forfeiture of vacation time.
Is the special contract provision your answer to Mr. Morris's argument that there are other specific statutes that explicitly say somebody should be paid his or her vacation, unused vacation time?
Yes, Your Honor. In addition to that, I would say there, as this court has made clear, it needs to read the employee-employer statutes as a whole, as a harmonious whole. And if this court looks at the Chapter 152, it says specifically in workers' compensation that vacation time is wages. If this court looks at unemployment insurance, it says specifically vacation time is wages. We would say that this section of the Act can be interpreted to mean that vacation time is wages, and I think this court has a duty to read these three statutes consistently. Just quickly, Your Honor,
Can I ask you?
Yeah.
I take it under Massachusetts law, an employer could allow an employee to have unpaid vacation. You don't have to provide paid vacation. Is that right?
That's correct, and EDS is also correct that certainly vacation time is up to the employer. We certainly are not arguing that vacation time is mandated under the Act, and certainly yes, an employer could provide unpaid vacation time. Quickly, Your Honor, I did want to point out that there are three Superior Court cases that are in support of the Attorney General's position, the Dos Anjos case, Einhorn Yaffe, and the court below. In addition, there's a lot of discussion about decisions out of state. The Supreme Court of Montana, Supreme Court of Oregon, and appeals courts in Indiana and Louisiana have held the same thing that we are asking you to hold, which is that wages are, vacation is wages and cannot be forfeited under the Wage Act. On the legislative history, if the court is really going to get that far and there is enough ambiguity in the Wage Act that it's going to get to the legislative history, we don't think the legislative history shows what EDS would argue. I think there's an equally convincing case that the legislature, when it was looking at this language, said, we want to make clear that we are not mandating vacation time. In its original provision, the word wages shall include any holiday or vacation pay due an employee, I think could have been interpreted to mandate vacation time. And the legislature specifically did not want to do that. Is there no further questions?
Thank you,
Thank you.
Mr. Conroy.